Good evening. I am Barbara Ballard, and I'm the Senior Associate Director at the Dole Institute of Politics. And we want to welcome you to our Constitution Day program. It is a pleasure for us to present this program because many of you know the mission of the Dole Institute of Politics is to promote political and civic participation, as well as civil discourse in a bipartisan, balanced manner. Often people will ask us, why are you doing our Constitution Day program? Well, on September 17th, 1787, the Constitution was signed by 39 of the 55 founding fathers. In 2004, President George W. Bush signed a bill designating every September the 17th as Constitutional Day. We do the preamble to the Constitution, and I will say to you, I will recite it, and in the process, I would like to ask you to listen carefully to the words of the preamble to the Constitution. And as I recite it, would you ask yourself, have we achieved these goals? We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. If you ask yourself those questions, have we achieved these goals? I think it's interesting to note that it says in there, to form a more perfect union. That means we are in the present. We are having an opportunity that we can continue to be striving to perfect our union. And that's really important because we can continue. It's an ongoing process. It is my pleasure this evening to introduce our guest speaker. But before I do, I will simply say to you, again, welcome to the Digital Dole Institute of Politics for the 2020 Constitution Day program. This program is sponsored by Mark P. Johnson. And tonight's program will include a question and answer session throughout. You may enter your questions in the chat window on the YouTube page. Please hold your questions until the Q&A sessions, and it will be after each case. The Dole Institute's mission is to foster civil and respectful discussion around important and often difficult topics. Please phrase your questions with this in mind. Questions that are distracting, disrespectful, or attempt to dominate the chat will be deleted and the user will be removed. This year's Constitution Day program will be moderated by KU Law Professor Lou Mulligan. Lou has worked with the Kansas Judicial Council, the Kansas Bar Association, the U.S. 10th Circuit Court of Appeal Criminal Justice Act panel, and the Board of Directors for Kansas Legal Services. I'm very excited for this program this evening, and I know you will enjoy it. And with that in mind, I will simply say, ladies and gentlemen, please welcome Lou Mulligan.
Thank you, Barbara, for that overly generous welcome. It truly is an honor for me to be here this evening. Before I introduce our special guests that are joining us, I'd like to take the opportunity to thank Barbara Ballard and Bill Lacey of the Dole Center for their leadership and many efforts in putting together our wonderful speaker series. As folks might well imagine, Zoom shows don't happen by magic. So I'd like to thank Mark Crabtree and Angie Italy from the Dole Center staff. I'd also like to thank Emily Depew, who's one of my first-year law students who's helping out. I assume she's studying for 8 a.m. civil procedure as well, but we'll see. I'd also like to thank Mark Johnson, who's one of Kansas City's finest election law First Amendment lawyers, for his years of service teaching at the KU Journalism School and the Law School, and for sponsoring tonight's event. Thank you, Mark. And most importantly, our audience. We're thrilled that you're all streaming this program into your homes this evening. We sure do wish we could be together in the beautiful Dole Center building, but I'm also quite sure your chair at home is comfier than the folding chairs we would have at the Dole Center. So if nothing else, a silver lining. And tonight we will discuss 3 cases that will be argued before the United States Supreme Court within the next 6 weeks or so. These cases are Fulton versus the City of Philadelphia, California versus Texas, and Jones versus Mississippi. The United States Supreme Court, or SCOTUS, if you want to be one of the cool kids, chooses its own cases to hear each year, and it only takes 80 or so annually. Thus, so every case at the High Court is a big case. I think the 3 we're going to discuss are especially likely to be impactful as we go forward. Because these cases are so likely to be impactful, many people and organizations other than the parties themselves seek to present their arguments and perspectives on the case. The Supreme Court will allow these non-parties to participate in briefing at the court in a practice known as amicus curiae, or friend of the court representation. Our 3 special guests this evening were chosen because they or their organization filed amicus curiae briefs in our cases today. And I would add, it's fitting for Constitution Day that our guests are all amici curiae, or friends of the court, who are here with their competing perspectives and experiences without devolving into a cable news shouting match, but rather being respectful of their fellow friends of the court on the other side of the issue while zealously advocating for their position. So without further ado, I'd like to take the opportunity to introduce our 3 guests in the order in which they will have our conversations today. First, I'm exceptionally pleased that Lauren Bonds will be with us today. Ms. Bonds is the legal director for the ACLU of Kansas. She was born in Hutchinson, Kansas, and attended the University of Kansas for her BA, where she ran Division I and was an All-American in track. She went on to Duke Law School, where she performed exceptionally well. Her work experiences varied from helping people obtain equal pay to voting rights work to criminal justice initiatives. Welcome, Lauren Bonds. We're happy to have you here tonight. Our second speaker tonight is Professor Josh Blackman from the South Texas Law School. Professor Blackman specializes in constitutional law, in particular issues before the United States Supreme Court, as well as law and technology issues. He received his law degree from George Mason Law School. And after law school, he clerked for Judge Kim Gibson on the United States Federal Court for the Western District of Pennsylvania. He has authored 3 books, and he's testified before the United States House of Representatives, as well as running a really cool fantasy SCOTUS online platform where you can predict your outcomes of cases. Thank you for being with us tonight, Professor Blackman.
Happy Constitution Day.
Yeah. And our third guest today will be Professor Larry Yackle. Professor Larry Yackle is a Professor Emeritus at Boston University Law School. Professor Yackle earned his BA and his law degree right here from the University of Kansas before moving on to earn his LLM, which is an advanced law degree from Harvard University. Over his career, Professor Yackle has written scores of books and articles, predominantly on constitutional issues, as well as post-conviction issues at law. He has chaired every committee under the sun and is a master of the profession, and we're quite honored to have him here. Welcome, Professor Yackle. So we'll start with Ms. Bonds and the Fulton case. Ms. Bonds, are you with us?
I am, yes.
Wonderful. Well, I'm glad to have you here tonight. So our first case is Fulton versus the City of Pennsylvania, or City of Philadelphia, Pennsylvania, excuse me. And it's an issue of religious liberty. I'd like to start though, if we could you tell us the basic facts of this case for our audience?
Absolutely. Thank you, Professor Mulligan. So this case, it involves government contracts with private agencies. So the city of Philadelphia, like virtually every other government, contracts with private entities in order to provide certain social services. And in this case, the social services being provided were foster care services. And the relevant party here is the Catholic Social Services. And Catholic Social Services, it does a number of things in the child welfare space, but the main services it was providing on behalf of the city were home visits and home inspections to prospective foster parents, and then also just general certifications of their suitability to provide a home to foster care children. And so the city and Catholic Social Services were engaged in this contract for actually a really long time, and without incident. So decades and decades, actually, they had this contract service together. And as I mentioned, without really any too much trouble. And throughout the duration of their contracting period, there had always been this contractual provision that Catholic Social Services had agreed to, that they weren't going to engage in any type of discrimination with respect to selecting foster care parents and certifying their eligibility to accept foster care children. And so that provision had always been in their contract and they'd always agreed to it. However, in practice, they weren't actually following it. Instead, whenever they would get a same-sex couple, they would refer them to another private agency. And so they were engaging in what would be considered discrimination on the basis of sexual orientation. And it's also important to note, though, that the city wasn't necessarily holding everybody to that contractual provision either. So they were permitting certain service providers to make determinations on the basis of the parents' on the parents' protected class status. For instance, if there was a African-American child, they might say this African-American parent is a better option for the child than maybe a different parent, just so they could stay within the community that was in the best interest of the child. So all this is going on. This contract is in place. This relationship is ongoing until 2018, when the Philadelphia Inquirer does a story about Catholic Social Services and another religious foster care service provider. And in that story, the Archbishop says, well, actually, we don't certify same-sex couples to be foster care parents. And so whether the city of Philadelphia knew about this before or not, they were kind of put on blast by this 2018 story by the Philadelphia Inquirer. And after that happened, they decided to end referrals to Catholic Social Services temporarily. And they also had a public hearing after that, in which a couple of statements were made that could be considered to be hostile towards the Catholic faith and Catholic Social Services as an organization. Things like, why don't you follow what Pope Francis is doing? Why are you trying to engage in discrimination under the guise of religious beliefs? And ultimately, that hearing, those public hearings resulted in the commission passing a resolution in which they said they were no longer going to contract with any private agency that wasn't complying with their municipal ordinance called the Fair Practices Ordinance. And the Fair Practices Ordinance prohibits discrimination in public accommodations for a number of protected class statuses, but sexual orientation is one of them. And so following the resolution being passed, the Catholic Social Services filed a lawsuit and a motion for preliminary injunction in the Eastern District of Pennsylvania. And that's kind of how this case started. And I would note that the ACLU's involvement in this case is as intervener. So we're representing several interveners. And I think that's important, not just to big up the ACLU, which I try to do whenever I can. But the Catholic Social Services really framed this case as a matter of the government is excluding this organization that just wants to help kids. And because the ACLU was representing a child advocacy organization and a foster parent advocacy organization, they were able to kind of reframe the case as, this is an organization that's excluding parents who want to help children or potential parents that want to help children. And so that's kind of how the ACLU got into this case.
Thank you, Ms. Bonds. So we have a case here where we have the Catholic Social Services that has sincere religious beliefs on interactions and placing children in same-sex households. And then we have the city who has non-discrimination policies, which it's constitutionally bound to apply. And we have this issue framed around the First Amendment, right? Can you, how would you frame this legal issue? What exactly is the First Amendment issue for us in this case?
So there's actually a couple of First Amendment issues, which is interesting. So there's a First Amendment free exercise claim, which I think is pretty much the central claim, at least the central issue that I think that the court's going to be interested in. There's a Establishment Clause, First Amendment Establishment Clause claim, and then there's also a First Amendment speech claim, that the claim that there's a form of compelled speech by having to comply with these non-discrimination provisions. And yeah, so I think the focus of the court and the focus of the briefing thus far has really been on the free exercise claim.
Indeed, and it has been, is the Catholic Social Services being denied their ability to express their religious beliefs and their religious practices. And then largely the parties are fighting on how they want to talk about this issue. The city of Philadelphia frames this issue as, we're contracting, and as a government contractor, we can add in requirements such as non-discrimination. And Catholic Social Services is saying, no, you're regulating us, and you can't regulate us out of our religious practices. So they're looking at the problem very differently, aren't they?
Yeah, and I think that distinction could ultimately determine how this case comes out on the free exercise question. I think most people in most courts would argue that, or would, without question, assert that, a person has a fundamental right not to be regulated in a way that infringes on their religious beliefs. I think fewer courts and fewer people, when you're asking, does someone have a right to participate in a government contract and then not comply with certain provisions in that contract, that doesn't sound like a fundamental right. I don't think most people would feel that that is a fundamental right. And so I think that that distinction could ultimately determine how the case comes out.
And in addition to that framing question, the parties are also fighting quite a bit over this case called Employment Division versus Smith. Would you like to give us like the 30-second overview of the holding in Smith?
Oh, sure. And I think it's important to know the just baseline facts, which is a case about whether the state of Oregon could deny someone unemployment benefits because they engaged in use of peyote within a religious practice. And so at the core of this case is created this framework that's really governed a lot of free exercise cases since. And that is kind of this distinction between laws that are neutral and generally applicable and laws that are explicitly directed at religious practice and or are motivated by animus towards a particular religious belief or practice. And this is important because if a law is neutral and generally applicable, it's subject to rational basis review, which is the lowest bar for the government to clear. If it is motivated by animus or it is targeted at a specific religious practice, it is subject to strict scrutiny, which is the highest bar for the government to clear. So whether a regulation is permissible can really come out in two very different ways, depending on how it's framed under the Smith analysis.
Right. So under Smith, which is an opinion that was authored by Justice Scalia, right, the Supreme Court ruled that one cannot come in and say, even if it's a sincere religious belief, one cannot come in and say, my religion requires me not to comply with this particular generally applicable neutral law. If the law was aimed just at a religion, different question altogether. But if everyone's subject to the same zoning codes or the same rules on use of Schedule I narcotics or so forth, there is no religious practice exception under the Constitution. And that case was not met with a lot of love, either at Congress or in the states. Was it, Ms. Bonds?
That's correct. There was kind of this backlash. I wouldn't say a backlash. There was a strong reaction to this particular case in the form of legislation. So there was the religious, I always forget RFRA, Religious Freedom Restoration Act. Yeah. And so there was a federal law that was passed, in the ACLU, along with a bunch of other organizations, advocated for its enactment. And then a couple of years after its enactment, there was a determination that it didn't apply to the states. And then there was a slew of states, I would say, that enacted state level RFRA statutes. And Kansas has one. We were a little late to the game. We didn't pass ours until 2013, but it really does return the standard of narrow tailoring and essentially strict scrutiny for any kind of religious infringement that occurs as a result of government regulation.
So there was some political pushback to the Smith case. So how does the Smith case, that holding, which says a generally applicable neutral law, right? There's no religious practice exception for that. How does that interact then with our case here in the Fulton case?
So that's a great question. And so Smith shows up in a couple of different places, and particularly in the petitioner, which is Catholic Social Services, within their briefing. So, there's kind of their initial argument, which is, even if Smith applies, this wasn't a neutral and generally applicable requirement. And we talked a little bit about that, how the government wasn't kind of uniformly requiring non-discrimination, particularly in its foster care contracts, because it was permitting certain determinations, at least, to be influenced by a person's protected class status. So they're making that argument. They also made the argument that there was some hostility in the enactment of this resolution to cancel contracts. And that was, the statements about, why can't you follow Pope Francis? So they kind of are making this one argument over here. And then in the alternative, they're saying Smith really shouldn't apply anymore, that this was a wrongly decided case, which is kind of a bold and ambitious argument to make, but it might be the reason that the court decided to hear this case in the first place. So Smith is kind of is at issue here, both because they're arguing, hey, we fall within these exceptions to general and neutral applicability, or neutral and general applicability, which the lower courts have found these regulations or these contract provisions are. And then also just saying, even though we can meet this test, we just should get rid of it in the first place. So
Absolutely. And I find it interesting, and I think worth noting for our audience, that we have stereotypically politically conservative legal interest groups and parties arguing against the Smith test, yet an opinion drafted by Justice Scalia, which I think highlights the fact that the justices aren't Republicans and Democrats. They have maybe conservative or more liberal judicial philosophies, but those don't always overlap one-to-one to contemporary political thought. What are your thoughts on that?
Absolutely, yeah, and I think that a lot of free exercise cases actually involve religious minorities, and then as they're applied over time, they apply to the Christian faith or other kind of majority religions. But I think that's an excellent point. We saw that last session and last term, and we're going to continue to see it. Is that you can't always guess how a justice is going to decide, because I do think, although they are ideologically motivated, they're motivated as equally by kind of enduring principles.
Absolutely, thank you. As we're sticking with the Smith case, and as Ms. Bonds noted, the petitioners in this case asked the court just to overturn Smith. So what would be the pragmatic consequences, one way or the other, if the court accepted that invitation and said, we're going to overrule Smith? How would our constitutional world change?
Absolutely, yeah. So, if we were to overrule Smith, I think that, one of the things that we would see is I think there is a, putting on my hat for the other side for a minute here, since the ACLU is an intervener in this case, but, I think there would be a much more uncomplicated analysis going forward. We wouldn't have to have these debates about what comments at a particular legislative session are hostile to religion, what in practice is generally applicable versus what isn't. So I think it would really kind of streamline a lot of free exercise cases and take a lot of the factual analysis out of things. So I think that, is one of kind of the practical realities that would result from overturning Smith. Additionally, I think it would make sure and ensure that, religious organizations could fully participate in all elements of public life and all elements of kind of government interactions in a way that maybe isn't happening right now. On the kind of the inverse, the kind of the negative things or negative practical realities that would happen is, it would really create this framework where so much discrimination would be permitted, and that there would be so many carve-outs for religious organizations to be able to say, hey, it's our sincere religious belief that integration is a sin, so we're not going to in this case provide or assign white foster parents to Black children, or women are subservient to men, so and a man is the leader of a household, so we're not going to refer foster children to single parents. I think just even looking within the context of this case, there could be extreme examples of discrimination, and just kind of taking a step away from kind of the legal consequences, it might cause the government to start taking on more and more of these, services that it's outsourcing, and put pressure on public budgets in a way that we haven't seen yet.
Absolutely, and we've seen the Smith case play a large role in many of the recent COVID era challenges to state orders across the country on plaintiffs arguing that Smith doesn't apply or should be overruled, and they don't have to wear a mask in church or can have more than a minimal number of people in a church building so that they can hold service, and these types of things, arguing that there's no regulatory authority. So beyond foster children, the Smith case, if it were to go away, could touch American life in any number of ways.
Absolutely, yeah, and I think that kind of current COVID climate is such a good example of that. Yeah.
So we looked at sort of the pragmatic pros and cons. What is your prediction? So I'm asking you to put on your Nostradamus hat, and then also tell the audience if they'd like to go ahead and put their questions into the chat, we would be happy to receive them. But what's your prediction, Lauren? Do you think, how do you think the court's going to come out on this one?
I think this is really a toss-up, and this isn't just my prediction. I went and tried to consult, people who are much, much smarter than me in terms of where they thought this was going to come out. And I think it really is kind of a big question mark. I think in light of the fact that we had Masterpiece Cake Shop very recently that, applied Smith pretty strictly, stayed within that framework and reached the result it did, that kind of suggests that Smith isn't going anywhere. At the same time, I think it's interesting that they would have granted cert on this case, and just kind of in light of decisions like Janus versus AFSCME, where we see the court reversing kind of very long-standing First Amendment precedent and jurisprudence. I think there's a strong argument that, hey, why did they take this case if they weren't really here to take a strong look at Smith? I think regardless, though, if I had to make a call and just had to pick a side, I do think that. I think that the Catholic Social Services is going to prevail in this case, but I think it's going to be under kind of existing Smith precedent, but who knows?
Indeed, it's a complicated question with 3 different issues presented that are a little more technical, which the court could use to wiggle out if it wanted to, than to decide the bigger issue. But as folks just looking on, we might hope for the bigger issue, just for the interesting discussion that would follow. Well, we do have a question from, I believe it's Braden. And Braden asks, do you see the traditional political rights as arguing against, quote, judicial activism of judges of the left as a criticism of the courts, or do you see both types of judges practicing judicial activism?
Yeah, I think that's an interesting question. So I think there are strong arguments that both sides practice judicial activism, but I think in terms of that particular criticism, we definitely hear it much more aimed at who we would consider liberal, left-leaning judges. But I think it's a bit naive to argue or take the position that that our justices aren't at all influenced by trying to achieve certain political goals or certain outcomes. I'm not saying our justices decide what they want and kind of work back from that result in terms of their analysis, but I do think that analysis is informed by your worldview, undoubtedly.
I would agree with you. I also think the term judicial activism, I think, is a bit like boo or yay. Any opinion one doesn't care for, you could call judicial activism. Certainly, critics on the left called the Heller decision, which was the decision that cemented the interpretation of the Second Amendment as an individual right as opposed to a right for militias. And many on the left said, judicial activism, you're overturning 80 years worth of precedent, boo. And on the right, when we get an opinion such as Obergefell or that type of thing, you will hear judicial activism. And is it much more than boo or yay? It's not clear that there's a neutral content to the term. So you gave us your prediction, and your 1/4 bet is certainly lodged with the Dole Center bookies on this. What's the best argument that you see for the city? So you suggesting you're not quite sure you're going to win it at the end of the day, but what's the best argument you see for the city in this case?
I think if we're strictly applying, and I think we covered a little bit of it, I think if we're strictly applying Smith, and I think if we're applying it within the context of this being an issue about, the government's right to contract, in which it has very broad latitude that this court has recognized, I think that's kind of their strongest arguments, is that, this is a general, neutrally applicable law. Everyone has to, apply and abide by these contract terms if they're going to engage with a contract with the city. And that's, facially what the resolution says. And this is a contract case. I do think that that's probably the strongest argument. And there is pretty significant support for, I think, that position as well.
Well, thank you, Ms. Bonds, for being with us this evening. It was a great pleasure. And thank you for all the work you do for us and for the state of Kansas. Thank you
so much, Professor.
We're going to turn now to our second case. And our second case will feature Professor Blackman. This case is the California versus Texas case. And in this case, the Supreme Court of the United States is once again looking at the constitutionality of the ACA, or the ObamaCare Act. Josh, are you with us?
I am here. Welcome. Thank you so much.
Wonderful. Well, it's not much of a factual story to tell us in here, but there is a long and winding road of legislation and lawsuits. If you could maybe take us to the beginning and walk us up to where we are today.
In the beginning, there was no, wrong story. Thank you so much. A happy Constitution Day to everyone, one of my favorite holidays. Although I think Constitution Day is unconstitutional. I think it's against the Constitution to mandate any institution speak on a certain issue. It's a violation of free speech, but I'm here voluntarily and not through the coercion of the state, so I'm happy to be here. The Affordable Care Act litigation has been going on for almost a decade. I've written now 2 books on this litigation, with a third in the works. Our story begins in 2010, when Congress enacted the Patient Protection and Affordable Care Act, also known as Obamacare. The Affordable Care Act had an important provision called the individual mandate. Now, the word individual mandate doesn't appear anywhere in the statute, but that is how this provision come to be known. The way Obamacare works is that people who want to buy insurance are able to buy it without discrimination. If you're older or sicker or having pre-existing conditions, the insurer cannot deny you coverage. And they also can't increase your premium if you are more costly to insure. This sort of protection, though, creates a risk. If I know that I can buy insurance at any point without having my rates increased, I may decide simply to go uninsured, risking it. And if I get sick, I go up and sign up for this healthcare policy. The mandate was designed to avoid this sort of free riding, what's known as adverse selection, where people can game the marketplace. So the mandate says you shall maintain insurance. Okay, and what happens if you don't maintain insurance? There's another provision of the law called the shared responsibility payment, which says if you don't maintain insurance, you have to pay roughly $700 a year, and that amount can vary. So again, one provision says you have to maintain insurance, and another provision says if you don't have insurance, you have to pay $700 a year. Okay. This law was challenged almost immediately after President Obama signed it into law. In 2012, the Supreme Court narrowly upheld the Affordable Care Act. Chief Justice John Roberts wrote the controlling opinion. And he said a few things that are important. He said, first, Congress cannot make people buy insurance, right? They can't mandate that you buy insurance. But the ACA could be read a different way. In many regards, the Affordable Care Act can be read not to mandate people buy insurance, but as a tax on the uninsured. Wait a minute, Josh, what's the difference? Well, as the law was drafted, it says you have to maintain insurance, and if you don't, you pay a penalty. Robert says you cannot do that. That's no good. You can't make people buy a commercial product. But he said if you read the law in sort of a different light, you sort of shift it, you squint at it, you glance at it, right? You give a different perspective, it might look a little differently. And the law as a whole could be understood as simply taxing the uninsured. Congress's taxing power is much broader than its power to regulate commercial activity. So where does that leave us? The chief said, the law as written is unconstitutional, but I will save the law. I will give it a saving construction to uphold it. And he says, because this penalty resembles a tax, I can consider the ACA as a whole as imposing this tax. Okay. At the time, people were angry, they were sad. I wrote a book about it. That's what I do. Fast forward a couple years. In 2017, President Trump becomes president, and he makes the promise that he's going to repeal Obamacare. That was never a credible promise. It simply wasn't going to happen. There weren't the votes to repeal it. But what they were able to do was to reduce the penalty to $0 and 0 cents. The penalty was now zip. The mandate wasn't touched. The Congress did not repeal the mandate. They simply reduced the penalty to $0. Again, these were separate provisions of the statute. Now, as soon as that happened, Texas and some other states said, the Chief Justice said that the ACA is saved because the penalty can be construed as a tax. It raises revenue. But the ACA no longer raises revenue. It raises $0. Therefore, the so-called saving construction simply doesn't apply anymore. And because the saving construction does not apply, we are left with an unconstitutional mandate to buy insurance. And if the mandate's unconstitutional, then other parts of the law have to go, or maybe the entirety of the law has to go. This is the issue that the Supreme Court will decide this term. Arguments we held, I think, the second week in November, right after the election. That was timed quite well. I think that was deliberate. But this is a case of California versus Texas. Now, why is it California? The Trump administration has declined to defend the ACA. They agree with Texas that at least part of the statute is unconstitutional. They're a little bit vague over which parts. They don't like answering that question. They're sort of hedging on a bit. but California has intervened to defend the Obamacare law. This case will continue no matter what happens with the election, whether President Biden, Vice President Biden wins or President Trump wins re-election. This case will stay. This is a significant issue that will be argued next month or in November.
Professor Blackman, thank you, because it's a complicated story, and you gave it to us well. I would like to highlight one thing for our audience. Almost going back to the comment you said, hey, is Constitution Day itself constitutional? Could you give us the 1 minute overview on the notion that Congress and the federal government is a government of limited powers, and that the arguments listed here are based on this notion that health insurance mandates aren't in Article 1? How do we do this?
Sure. You are all in Kansas. I am sitting here in Texas. We have 50 states. In our system, the states have the first crack at doing stuff. The states have a broad power to protect the health, safety, welfare, and morals of the people. If you notice during this pandemic, almost all the health laws came not from the president, but from the governor. There's a reason. The states have primary responsibility for the health of people. They have lots of power. The federal government doesn't have that sort of broad power. They have specific powers that are listed in the Constitution. They're listed, they're enumerated, they're basically numbered right in the Constitution. The ACA case presented the question, is the power to make you buy insurance one of those listed powers? The states can make you buy insurance. Not much of an argument against that. I can make one, but not tonight at least. But there had never been a purchase mandate from the federal government. And that's why the Obamacare case was such a significant decision. Could Congress make you buy a commercial product that you did not desire? The state can make you wear a seatbelt. The state can make you buy insurance if you're driving a car. But can the feds make you buy insurance as a mere product of existing, that because you exist, you have to be under this mandate? And that was a question presented.
And that's why Chief Justice Roberts then, when he reframed a saving construction, reframed it as a tax penalty, because the taxation power clearly is part of Congress's powers. And now we've perhaps taken that away. I'd like to start, Professor Blackman, before we get into the pros and cons of this argument, a little detour into this concept of standing. And so for our audience at home, standing is a limitation on the power of the federal courts. And so the federal courts can only hear things of a judicial nature. And usually the court says, among other things, that you have to have an actual injury in fact. Here, the argument around standing is this: Congress has made the penalty, as Professor Blackman said, zero. So how are you harmed? Either you buy insurance that you want, or if you don't, you pay a penalty of zero. So where is the injury in fact that gives the courts power to decide this case?
Thank you. Here's another way that federal courts and state courts are different. In state court, you can bring just about anything you want. Any sort of dispute you can bring in state court. I know in your state you had this dispute between the governor and the legislature. Am I right? Was that Lou? Is that right?
That
would never fly in the federal courts, right? State courts can hear just about any case they want. Federal courts are more limited. They have what's called limited jurisdiction. The word jurisdiction is a fancy word that just means what kind of cases can a court hear. One of the basic limitations is that you can only go to court if you're injured, right? Has the government injured you? You know, maybe they've assessed a penalty or a fine. Maybe they've arrested you, right? Maybe they've enacted a law that regulates your business. When the government takes these actions, you're injured. You have basically a standing to sue, what's called standing. This case, the Obamacare case, presents an unusual argument for standing, and I admit it's unusual. But it's only unusual if you don't know the history of this case. The penalty was reduced to $0. If you don't want to buy insurance, you don't have to pay a penalty. So the argument goes, how can you be injured by a $0 penalty? If I go to you and say, hey, you know, Professor Mulligan, give me $0 or else. You're like, okay. All right, thank you. Right, give me $0. even if it was a penny, there'd be an injury, but $0. Now, the answer to this question has to do with the way this case has been litigated before. I said at the outset of my remarks that the mandate and the penalty are different provisions. In the first Obamacare case in 2012, the plaintiffs did not challenge a penalty. In fact, they argued they would never pay the penalty. The penalty would only be assessed a couple years in the future. And in that case, the plaintiff said, we are going to follow the mandate. We are never going to pay the penalty. In other words, in the first Obamacare case in 2012, standing injury was premised entirely on the mandate. The requirement to buy insurance was a pocketbook injury. I have to buy insurance, or else what? The or else what didn't matter. What mattered was the requirement to buy insurance. If you don't believe me, maybe you don't know me, you can go back and watch the oral arguments from 2012. And Chief Justice Roberts and Justice Kagan were asking, what happens if a toothless mandate with a $0 penalty? They were anticipating this issue, right? So this has been vetted. I'm actually pretty confident on standing. We'll get to severability in a minute. That's kind of a train wreck. But on standing, I think the plaintiffs got it. This is a requirement to buy insurance. It's unusual, but I think it's an injury in fact.
So the idea here is that there's an injury, not because of the penalty, but because of the requirement.
Right.
And it's the sheer fact that the government's mandating you, even if it doesn't have much of a stick or any stick at all, that the sheer mandate itself creates the injury. Well, let's move then to the merits, as it were. And so in some sense, the issue here is this still a tax? Or is it not a tax? Arose by any other name would smell. So is this a tax, constitutionally speaking?
Well, the Chief Justice wrote this very unusual opinion in 2012. He did not say that the ACA was actually a tax. If he said that, would be easy, right? He said Congress did not enact a tax. Rather, he said the law can be read as imposing a tax if certain conditions are satisfied. One of those conditions is it has to actually raise revenue. The core feature of any tax is it generates money for the government. As things stand now, the ACA does not raise revenue for people who go uninsured. There's no revenue being raised. I don't think the saving construction saves anymore. I think we're back to the ACA in 2012 without the saving construction. And I think the mandate's unconstitutional. Of all the questions in this case, this one's the easiest. I'll tell you, the state of California barely defends on this point. I think they'd be willing to say, all right, just say the mandate's unconstitutional, leave us alone. Let the rest of the law stand. There's not much of an argument. I think there's some I can raise, but this I think is one of the easier aspects of the entire case.
So in your view, then, if Congress had said there's a 1 penny
That's fine.
fine, then we would have raised some revenue, and that would then be a constitutional tax, and off the races we go. But because they went literally to zero, that's when it crossed the constitutional line in your analysis.
Penny saved, the penny earned. That will save the law. And in fact, if you want to get meta on me, I know you do jurisprudence. Let's say Congress restores the penalty tomorrow. The AC becomes constitutional again. It's basically brought back from the dead. You have a zombie statute, right? But even if the court says it's unconstitutional, if Congress raises the penalty, it would resurrect. Think about that one for a minute. But I think it's absolutely the case. I actually call it Schrodinger's mandate, where it's both constitutional and unconstitutional at the same time. It's a sort of paradox of law. Welcome to John Roberts' world.
If I were to task you to give us the best argument on the other side on the tax, what's the best argument that this actually is still constitutional, even with a penalty of zero?
Yeah, it's one that I'm actually very nervous about. I think it's a good argument. Not everyone pays their taxes on time. People postpone their taxes, they delay them, they're delinquent. Even though the penalty was zeroed out in 2017, not everyone has paid their penalty yet. There's some people floating around the world, they exist, who haven't paid yet. So if there's one person sitting in Lawrence, Kansas, who has not yet paid his penalty, and he decides to pay it next year, there's revenue, there's your penny. So this is one I've been dreading because John Roberts likes to twist a knife in my heart every year. This is how he does it. It's like, well, there's a guy in Lawrence, Kansas, right, who hasn't paid it yet. So there you go. That's the best one.
Do you think that the court will be take that much of a off-on switch as opposed to a dimmer switch, to use an analogy, approach to what a tax is? Or do you think there'll be that bright line about it?
Look, Professor Mulligan, the Chief Justice finds a way to disappoint me every year. And this is one way he could do it another year. It would not be the court, it will be him. And, the other justices, they'll just go along with whatever he writes. Doesn't matter. They just care about the bottom line. So this is one that I'm like, oh, this is such a Roberts argument.
I have one or two more questions for Professor Blackman, but if folks in our audience want to send in a few more questions, please go ahead and do so while we go to our last topic to discuss, which is this idea of severability. So severability is the notion that sometimes a statute has, let's say, 10 parts, and perhaps part 7 is unconstitutional, but parts 1 through 6 and then 8 and 9 are constitutional. Do we just excise, like a surgeon, the one unconstitutional bit, or does the whole thing have to fall because it's all interrelated?
Yeah,
how does severability relate in this case?
Let me use a gross example. So let's say you have gangrene, right? And you have gangrene in your toe, your big toe. You might be fortunate and they can just cut off the toe and then you're fine. But sometimes the gangrene spreads to your foot and they might have to amputate the foot. And maybe they have to amputate below the knee. And maybe they have to amputate the entire leg. And in some rare cases, the gangrene spreads and the patient's lost, right? The patient cannot be saved. That's basically how severability works in the Supreme Court. You have this infection, this unconstitutional problem. And the courts try and cut off as little as possible to save the body, to save the entire statute. But sometimes if this unconstitutionality spreads throughout, you have to cut off more and more and more and more. And if the infection is so wound up with the entire statute, you have to kill the law. There's a question I see in the chat from Kevin who asks, why couldn't the court have just sent the entire thing back to Congress for a blank slate? That's what the 4 dissenters wanted. They said, look, we can't carve up the Obamacare like a Thanksgiving turkey. You get some dark meat, you get some white meat, you get the leg. You can't carve it up like a taxidermist, right? We're not butchers here, we're judges. So just kill the entire thing, send it to Congress on a blank slate, and let them work from scratch. The chief did not do that. He saved it, but didn't really save it. He sort of just created a facsimile, a copy of it that exists in this alternate parallel Schrodinger's box where it depends on how much money is being raised. So we're stuck in this thing. So the severability analysis is actually really complicated because there's 2 Congresses involved. This is a mess. In 2010, Congress enacted the ACA, and in 2017, Congress enacted the repeal, the zeroing out of the penalty, the FONS AA, right? The happy days are here again, right? The issue here is which Congress's intent controls. By 2017, people realized that the mandate wasn't actually that important, that you could have Obamacare without the mandate, you can just zero out the penalty. But in 2010, people thought that the mandate was the most important thing in the world. You couldn't live without it. And that if you didn't have the mandate, the entire law would have to go. So whose intent controls? If we look at the 2017 Congress, that suggests that maybe just the mandate goes. You just sever the toe and the rest of the body, sort of hops along. If the 2010 Congress controls, then maybe the entire patient has to go and start from scratch. These are hard questions. I don't have nearly enough time to explain. Those are the rough issues.
What's your crystal ball prediction on severability? So we know where you stand on sort of the merits. You believe this is a pretty easy call, unconstitutional. Do you think they'll be able to conjure up a severability analysis, or the whole thing goes?
Oh, I don't think there's any chance the whole thing goes. I don't think anyone thinks that's going to happen. It's maybe there's 2 votes for that position, although I'm skeptical. The reason why is this is a law that's been in effect now for almost a decade. In 2012, it was kind of new, right? No one really knew what it was, whatever. Now it's a pretty big deal. So I don't think they killed the entire thing. I did an amicus brief. You mentioned amicus brief, friend of the court briefs. I did a friend of the court brief for the Cato Institute, which is a libertarian group in Washington, D.C. And we argue sort of a middle of the road approach. We say, well, the ACA's mandate's unconstitutional, and some of the regulations are unconstitutional as well, but you don't need to kill them for everyone, right? There's some people who like Obamacare and aren't claiming an injury. So maybe the court can say, if you like Obamacare and you go in the Obamacare marketplace, keep your policy, right? Keep your regulations. But if you want to buy a policy off the exchange in the private market, well, in those places, you're not bound by these regulations. And we crafted this argument with an eye towards his glory, John Roberts, and Justice Kavanaugh as well, as perhaps a middle ground that you leave Obamacare in place for most people, but for those who feel an injury, those who feel injured by it, they would have an opt-out. That was the best I can come up with. The most likely outcome is the court says the mandate's unconstitutional, and we stop there. I get to write a book about it, and nothing in the world changes. This is basically how my life works.
But you still get to be a tenured law professor, so it won't be that bad.
I have the best job in the world, don't we, Lou? Isn't the
yeah,
best
absolutely. Blaine asks, going back to your earlier prediction, but Blaine asks, the court or Chief Justice Roberts has gone through pains to uphold the ACA multiple times.
Yeah.
Is there really any chance the court or Chief Justice Robert flips in a meaningful way this time?
Pains, very painful, very painful.
Yeah.
Yeah, Blaine, I hear you. I think the chief will issue a decision that makes everyone angry. I think, we're taking a step back. We're talking a lot about Roberts. I think when John Roberts writes an opinion, his goal is to make everyone angry on both sides of the issue. If everyone walks away infuriated, it's a good John Roberts opinion. He does it every year. He did it in the DACA case. He did in the Little Sister of the Poor case. He does it just in the census case. Just everyone's always angry at him. And I think that's where he wants to be. He wants people just to be unhappy with him on both sides so that we can say, see, look, I'm not pleasing anyone. I don't know. I don't think there's any chance he limits it, although the brief I wrote might give him an out that could cause minimal disruption, but still actually follow through in his opinion from 2012.
Well, thank you so much, Professor Blackman, for your discussion of that case, and we'll look forward to seeing that decision, and then in a couple of years, reading your next book on it. Thank you so much.
Thank you.
We're going to turn for our last discussion to the Jones versus Mississippi case. We'll be joined by Professor Yackle for this discussion. This case raises questions regarding life in prison without the possibility of parole when the criminal defendant committed the crime while a minor. And so we'll turn to Professor Yackle. Are you with us still? Professor Yackle?
Yes, I am with you.
Wonderful, wonderful. So we're moving to the Jones case. Could you begin with a little discussion of the factual background of this case for us, please?
Brett Jones was 15 years old when he killed his grandfather. There was an argument, a fight in the kitchen of the grandfather's house. Brett Jones killed the grandfather with a steak knife. He said it was in self-defense. The jury didn't believe him, and he was given a sentence of life without the possibility of parole. If he doesn't win this case, he will spend the rest of his natural life in a Mississippi state prison. He was 15 when he committed the crime. He's about 30 now. He will spend the rest of his life well into middle age and old age if he lives that long. And he will never get out. He will never be considered for parole. Of course, parole consideration is a fairly routine thing for most criminal offenders, but not for Brett Jones.
Could you share a little bit about some of the extenuating circumstances? He was a young person under considerable duress at the time, was he not?
Well, he was the child of abusive parents. The grandfather was abusive. It was not a pretty picture at all.
Right, and it seemed as if during the commission of the crime that he was in a flight or fight panic. It was not a premeditated murder or anything of that nature, was it?
Well, it was murder. He was convicted
sure.
of murder and received this very serious, brutal penalty.
So this case then raises this question, and it's wrapped up in an application of a prior Supreme Court case called Miller versus Alabama. Could you explain for us what the Miller versus Alabama case, that ruling was about, and how that would then apply to our case?
Well, Miller was decided in 2012. It is a pertinent background precedent. I don't think it's critical necessarily to the resolution of the question before the court in Jones, but it certainly is an important precedent that the court is likely to examine in deciding the question in Jones. There's a controversy about how to understand the holding in the Miller case. My point of view, and the point of view of many, is that Miller decided that kids are different. Kids are not like adults. They're not fully formed in their personalities, their emotions, their intellects. They are young people who have diminished capacity, diminished culpability and enhanced capacity for change. They're not like adults. And so the sentencing of kids takes on an entirely different character as against the sentencing of adults. The issue in this case is whether a sentence to life without the possibility of parole constitutes cruel and unusual punishment in violation of the Eighth Amendment. Now, the Eighth Amendment embodies familiar principles of rationality, proportionality. The idea is basically that a criminal penalty needs to be in furtherance of some legitimate objective. And in the case of juveniles, as a class, in the case of juveniles, a sentence like this, life without parole, is systematically disproportionate. And that's one way, certainly, to read the Miller opinion. And if the court does read it that way, that would be a powerful precedent for siding with Brett Jones in this case.
And it, more specifically, at least one way of looking at the Miller case is that the court held that the overwhelming majority of the time, a juvenile offender should not be sentenced to life without parole. Isn't that the case?
Yes.
And they put one qualifier though on that. And what was the one qualifier, the one exception, if we want to look at it that way too? Kids never get life without the possibility of parole, except for in certain circumstances.
There are differences of opinion about what Miller held. But one point of view, and the one I think you're angling toward, which is the point of view that Brett Jones advances in this case, is this: that some juveniles, despite their young age, break the pattern. They are fully formed. Their characters are fixed as though they were adults. They don't share the characteristics of juveniles generally. They're outside the class of juveniles generally. And these young people, despite their age, can be constitutionally sentenced to life without parole. But they are a rare breed. And the court in the case law identifies them as the permanently incorrigible. Now, footnote to this point, I don't think there are any permanently incorrigible children. But the argument in this case proceeds from the premise that there might be. So the argument that Jones makes, and one can draw support from the Miller case for this proposition, the argument that Jones makes is that his sentence to life without parole was unconstitutional because the sentencing court didn't determine that he was permanently incorrigible. that's a condition precedent to a valid life without parole sentence for a juvenile. That's the argument.
Thank you. And so his position is, I didn't have that opportunity to have that particular finding there. I know that Mr. Jones and the state of Mississippi have different views on what the background case law is. Could you outline for us how Mississippi looks at the background law, this Miller case and the satellite cases around that decision?
Mississippi's position is that the Eighth Amendment is satisfied if the sentencing authority, in this case the trial court, considered the characteristics associated with youth. It's not necessary that the trial court, the sentencing authority, make a determination that the particular offender is permanently incorrigible. It's enough to satisfy the Constitution if the characteristics we usually associate with youthful offenders are considered.
Right. And so what Mr. Jones is asking for in this case is that when he was sentenced, there should have been a particular part of the trial or hearing where they would have directly looked at this question of incorrigibility and made particular findings. You are or you are not falling in this category. And the Mississippi State Court System has never engaged in that process for him.
Well, that's right. If it is the case that the Eighth Amendment bars life without parole for the large class of juveniles and allows for it only in the case of juveniles who are outliers from the class, the permanently incorrigible, then it follows that in order to impose a valid life without parole sentence, it's necessary to determine that the particular offender in a case is permanently incorrigible.
Right. And so what would, just for the life of Mr. Jones, if he were to win in the Supreme Court, what would this mean for him? Does this mean he would be free? Does this mean he would have a new trial? What would this mean for him?
It has nothing to do with guilt or innocence. It has only to do with the validity of his sentence. And with respect to that, it has only to do with eligibility for parole. If he succeeds, Mississippi could respond by giving him another sentencing proceeding at which he could be sentenced to life without parole only if he's found to be permanently incorrigible. Alternatively, it would be open to Mississippi, if Mississippi didn't want to go to that bother, just to declare him eligible for parole. But he doesn't necessarily get out of jail, but he might be considered at some point for parole. And depending upon the conditions at the time, the parole board might well set him on some kind of conditional release, parole.
We have a wonderful question from Anne, and she asks, what science is the phrase permanently incorrigible based on? And I guess perhaps another way of thinking about this would be her question, what would the type of evidence be if one were to have, as part of sentencing, what sort of evidence would be put on to determine whether a juvenile offender was permanently incorrigible?
Well, to my way of thinking, again, there aren't any such kids. Kids are unformed. They can change and are likely to change. I don't think that Brett Jones is the same person today that he was 15 years ago. But in the case law, including Miller, there is some attention and respect to the idea that there may be these rare outliers. And I take it that in order to demonstrate that someone is one of the outliers, a permanently incorrigible person, the state would bring in evidence of this person's personality, his background, presumably professional opinion about him, about his emotional and intellectual development, the prospects for his maturity, things of that sort.
And I might add to Anne's question, in some sense, I think her question is asking, did the Supreme Court consult science and psychologists and child psychologists when they came up with this term permanently incorrigible, or did they just sort of make it up as they went along, like they do a lot of things?
Well, this isn't the only term. There are other terms used in Miller and other cases, but this captures the basic idea. And yes, amicus briefs often help the Supreme Court understand the psychological literature, what we know or think we know about human beings and development. So it's not as though the Supreme Court does this in the air. It does have help. And those studies are often cited in Supreme Court opinions to explain why the court takes the attitude it does about juvenile offenders.
And it also, I think, brings up the notion that the court system, acts very differently than Congress. So, the court system is not going to have a series of experts who come into hearings and we would ask things and write things. It's one appellate argument, and then they retreat into their chambers and read and write and study and work really hard. But it's a different process than one that sort of evolves with the science or that type of thing.
Well, I don't know that I agree.
Mm.
I think that the Supreme Court gets a lot of good information about the way the world works in various ways, including amicus briefs and the briefs of the parties. And it's not as though the Supreme Court can't do research itself into these fields. And that's the kind of thing that Congress does when it holds hearings. I don't know that the difference is all that great qualitatively.
Yeah. What would a win for Mr. Jones mean for the juvenile justice or criminal justice as a whole? What would that impact be more systemically?
Well, I think the world would be a better place if Jones were to get a chance for another sentencing hearing and perhaps a sentence that will allow for parole. That in itself would be of significance in my mind. But it's also true that if Jones wins, then other similarly situated offenders would have the benefit of the decision. People in future would be entitled to sentencing hearings that focused on whether the offender is permanently incorrigible. And the Supreme Court has odd arrangements for determining these things, but the court would also say that anyone whose life without parole sentence already imposed but and not yet final would have the benefit of the decision. It's also true that some offenders sentenced since Miller might have the benefit of a decision for Jones here. There's a complicated set of arrangements about who has the benefit of Supreme Court decisions. Generally speaking, the court has it that if it announces a new rule of criminal procedure, then the offender at bar, future defendants, and someone whose sentence has not been finalized, those are the people who get the benefit of the court's decision, nobody else. But in this case, remember, my point of view is that Miller essentially decided this back in 2012. So it's not new. It's not a new rule at all. That is to say, if the court were to decide for Jones and were to embrace his argument, then I'd want to say it's not a new rule at all. It's one that has existed since Miller. And as well, I'd want to argue and would and do argue in the amicus brief that the Miller rule is not procedural, that a decision for Jones in this case is not procedural, it is substantive. Now, this is a messy distinction, substance and process, but if you have it, if you characterize a decision for Jones in this case as one of substantive law rather than procedural law, then anybody who has ever been sentenced to life without parole as a juvenile would have the benefit of the court's decision.
And that would be a big impact across the country. Are juvenile or sentences for crimes committed while someone is a juvenile for life without parole common or uncommon? And I realize that will change state to state, but if you were to look nationwide, is that a large feature of our juvenile justice system or a smaller one? And before you answer, I would invite our audience to please go ahead and feel free to submit questions while Professor Yackle responds.
It does vary state to state, and it changes over time. Many states still authorize the penalty, but it's rarely imposed. Many states have authorized the penalty in the past, but largely since Miller have allowed for resentencing. And offenders who were sentenced to life without parole previously no longer have that sentence. So it changes pretty dramatically. Certain states tend to use this penalty more than others. Pennsylvania used to use it a lot, no longer does so much. Michigan still uses it fairly consistently. Mississippi, Louisiana, these states as well. When Miller was decided, there were 2,500 juvenile offenders serving life without parole. I don't know how many there are now. It surely must be in the hundreds. And if it's fewer, it's because that states are beginning to realize just how brutal and inappropriate this sentence is.
And so this a big impact, not only for hundreds, if not thousands of individuals, but in terms of even how criminal justice would proceed. So at the risk of asking you to break out your crystal ball, where would you put your 1/4 bet on how this case comes out?
I think Brett Jones is going to win because he's right and just. His position is just.
And you think he can stand on with both legs on the Miller case and say, you all have already decided this before, let's just apply it fairly, and this is the just outcome.
I think he could, but he doesn't have to.
Yeah.
It's not that his argument turns on whether his argument can somehow be found in Miller back in 2012. His argument is fresh today, whatever Miller decided.
Yeah. And do you think there'll be any takers for the Mississippi position?
Oh, I can't count noses on the Supreme Court of the United States. If I tried, I would fail. I can't predict that.
All right. Well, thank you so much, Professor Yackle, for your time this evening and enlightening us on this case. And before I turn it back over to Ms. Ballard, I just wanted to thank all of our speakers for their insight and time this evening. It's a treat to have folks from all across the country join us with such different perspectives and different backgrounds to bring for all of us to learn from. So thank you all very much. And with that, I will turn the platform, if that's the right term, back over to Ms. Ballard.
Wow, thank you so very much. I really want to thank all 4 of you, Lauren Bonds, Josh Blackman, Larry Yackle, and Lou Mulligan, for an outstanding program. When you listen to each of those 3 cases, you know, it's compelling in so many ways. And I will be looking at what the opinions might be to see how close we all got to them as well. So, you know, if you were here, we would give you a warm Jayhawk welcome. And I will give you a silent applause to just say thank you so very much for your time and your expertise and for helping us with Constitution Day. I have to think with Professor Blackman in terms of it's maybe unconstitutional to be making it mandatory for people, but nevertheless, you showed up and you did it, and I want to thank you very, very, very much. I sat through all of it, and it was just really fascinating. And I have to give a special thanks to our moderator, This is the first time he joined us at the Dole Institute of Politics for this program. And we want to thank him for accepting the invitation to join us. You did an exceptional job as moderator. And thank you so much for choosing the topic that I think is extremely timely in many ways at this time. So again, thank you all very, very much. I would also like to invite our audience to attend next week's program. And it's Ed Riley's lecture next Tuesday. And it will feature former Congressman Jason Edmeyer, and he will join us and he will talk about his book, Dead Center, How Political Polarization Divided America and What We Can Do About It. The Dole Institute of Politics is sponsoring KU's Civic Engagement and Leadership Month. And it started yesterday. Well, yes, it did, September the 14th, and we will end on October the 13th. So we have lots of programs, especially around civic engagement. And they're all, I think, exciting programs with outstanding guests. So again, I want to thank everyone for joining us this evening, and especially our guests. And I will say again, thank you very much. It was a pleasure. Good night.
Thank you.